and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So, at this point in time, is there anything else you want to tell me?
Yes, Judge. There's quite a few other things. We would ask for you to be recused from this case because you are a witness.
This is everything that went down in the courtroom when Ashley Merchant came in to defend or to represent Brian Steele after he was found in contempt of court. All right, y'all check this out. Ashley, she was taking some shots.
Orderly process of the administration of justice, the preservation of order and decorum of the court is exempt from due process requirements of notice and hearing. That's even Moody, goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him just to release or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merchant, and not answer a question of the court and not be held?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is...
Now, let me give you a little bit of background here in case y'all didn't know. So what happened is this happened on Monday, I believe. On Monday, Brian Steele, Young Thug's attorney, found out that the prosecution, the judge, and now we know, which we're going to get into later, that Lil Woody, who is testifying in this case, had a meeting without the defense, which is a no-no. Right? It's called, they call it ex parte. I'm not going to go into the definition. I know there's a couple people in the chat who can look it up and help y'all out with that. So anyway, that's a no-no specifically in this case. And Brian Steele was upset about it. He said, I want to call for a mistrial because you guys are having this meeting without me, which isn't allowed. Now, the judge wanted to know who told him that that meeting took place because Brian Steele wasn't supposed to know, which is crazy. Judge Glanville is basically saying you weren't supposed to know about the secret meeting. Who told you about the secret meeting? Brian Steele said, I'm not telling you. All right. So because he wouldn't tell him who was holding this secret or who told him about the secret meeting, he held him in contempt. He got taken into holding. Then at the end of the day, he gave Brian Steele a chance to tell him and he wouldn't be held in contempt. Right. So now word got out to this group of attorneys. The leader of the group of attorneys is Ashley Merchant, and she came there to defend Mr. Steele. All right. So this is what they're going back and forth about. He's like, you shouldn't be. I'm just going to play the video.
And or hinder, obstruct the orderly process of the administration of justice.
Hopefully y'all can hear it.
Preservation of order and decorum of the court is exempt from due process requirements of notice and hearing. That's even Moody, goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him just to...
He said he wants him to snitch. And we're going to talk about Lil Rod a little bit later, but Judge Glanville is not looking good in this case. There has been so many missteps on his part. And man, y'all, it's looking like Thug might be free. They might get Thug out of there. Just keep listening to what happens.
Release or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merchant, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith.
Ashley is cooking over there. Ashley is cooking Judge Glanville. So yeah, she's saying, one, what happened outside of this court doesn't have anything to do with this case. So you shouldn't even be holding him in contempt because you're bringing up these charges and you can't. Oh, it's just this the whole thing is just a whole. It's a mess.
He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you aren't part of them. By nature.
Yep.
You have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also.
But you got the information. But here's the thing: you got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I said that. Dang. One of the things is it's either.
And see, Judge Glanville, he is saying he's eavesdropping. He said that. So he said, I'm not saying he's eavesdropping, but you did definitely accuse him of that. He said, I don't know how you got this information, but you either got it from a person, you're eavesdropping, or I don't know what other way, but it has to be one of those 2 or 3 things. Jeez, man.
From an improper methodology. I'm not saying that he eavesdropped. Okay, I said that one of the things is it's either one of 2 ways. He either eavesdropped, which I don't believe he did at all. I don't believe that for a minute. But I do believe
it's dirty, man.
Tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court
which is wrong.
Has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a.
Come on, Judge. So basically, his argument is, okay, we had the secret meeting that we weren't supposed to have. That's fine. But the issue isn't that we had a secret meeting that may or may not be illegal and compromise this case, right? Let's just push that to the side. You shouldn't have found out about this information, because if you found out about the information about the secret meeting that we weren't supposed to have, then someone that's representing the court, someone within the court, has to be held accountable for that. And that's the issue. This is wild, man. So Judge Glanville is not taking into account that he held a meeting without the defense there. It's crazy.
With somebody, and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So, at this point in time, is there anything else you want to tell me?
Yes, Judge. There's quite a few other things. We would ask for you to be recused from this case because you are a witness necessarily.
Yo, Ashley Merchant is cooking him. She said, Judge, you got to get out of here. You should be recused because now there's a conflict, right? If we're having an issue on one side, and then the issue is with you and you're making rulings on that issue, we can't have you here. We can't have you here. You got to recuse yourself. We all know what Judge Glanville is going to say.
Other things. We would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge.
Jeez.
And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing.
And it's specifically, the reason is because it was, I think it's because it was criminal contempt. That's the issue they're having here. And he repeatedly said that as well.
Notice of the alleged violation, whatever rule it is that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
Guess what he's gonna say? Y'all let me know. What do you think he's gonna say?
I'll let an appellate court decide that.
Oh!
Anything else?
Oh man, y'all saw how he backed up his chair. Again, I'm not going to get into the details. If y'all want to do your research on that, you can. But he said, "I'll let appellate court handle that." Y'all, that is a threat. He said, "Okay, you want to take this all the way? We can do it." And he backed up his chair. He's about to get up. He said, "Either way, I'm standing on it. Get Mr. Steele out of here."
No, we'll file a notice of appeal.
Jeez.
Okay.
And we need to have the order reduced in writing as well.
I'm going to do that right now. I will state for the record at this point in time that Mr. Steele has in fact or has filed, and I will note this as part for the record in this case.
And Judge Glanville, he actually wrote up everything last night at some point.
He filed a motion to set aside the contempt. He's filed a
Dang.
motion for a supersedis bond, and he's filed a notice of appeal, all of which I will include as the next court's exhibit in order. But I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself of the contempt just by telling me who it was, and he can do that this evening. He can do it right now. He can do it at any point in time. If not, I'll reduce
Nah, why would he do that?
On Friday.
And Judge, we would ask that you grant the bond. At this point, criminal contempt, he's got to be sentenced.
Well, his
Here we go.
Is as long as he when he tells me what the basis of the conversation was, who I didn't ask what, but he tells me that, then I can certainly he purges himself of the contempt.
Then that's civil, Judge.
That's civil contempt.
That's civil.
Judge, and that's respectfully, I would point you to In Re Hughes, which stands at the same point of law. Civil contempt impose punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred.
And basically they're using this as a play to make some moves on the defense side. Now, the difference between criminal and civil in this situation is going to be a big deal because it's going to determine how they move forward with this case. But as y'all can see, Judge Glanville, he is not budging.
Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge, which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk.
It's a big deal.
And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in the loss of his license.
Yeah, which is
So
bad.
In a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story. And
I'm not doing that. The reason being is because that takes away the whole point of criminal contempt, and that is you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical.
Well, that's the point that they're trying to make, though. It could be what you're asking him to do could be illegal, immoral, or unethical, especially if something does happen with this situation further down the line. So, I mean, man, Brian Steele's in a bad situation here. It's really a no-win for him, but thankfully he's only got to do a few weekends here, but still, this is just a bad look on the judge's part.
I know what the privilege is. The privilege is the conversation. I didn't ask him about that. I wanted to ask him about who, the person, because okay, I'm sorry.
Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
Okay.
Yep.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond, but I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about this a second, okay?
And he said he wanted to think about it. He went and thought about it, and he said, yeah, it's still contempt. So, man, we got to free our guy, Brian Steele, man. Lawyer of the year. One of the most elite lawyers here in Atlanta. Killing the game, and we'll see what happens from here, because this isn't the last we're going to hear about this meeting. And I know the defense is going to keep this tucked in their belt, and we'll have to see what happens once he's done all of his time. Once he's done this 10 weekends. Jeez, man. Once he's done these 10 weekends in prison, what's going to happen after that? Is Judge Glanville going to bring it back up again? Throw him back in there? I mean, hey!